As you all know that current affairs plays a very huge role in prelims examination 2026. Under Vijay Baba, the current affairs is been planned such that minimum to 20 questions and maximum 30 questions. If I tell directly, it is not questions, it is topics. 20 topics minimum and 30 topics we can expect in the prelims examination 2026. And for every class, I will be giving the printouts for offline students in this format. The complete what I am going to teach in this particular classroom, the printouts will be given to the offline students for the next 20 classes, 40 hours of sessions, 40 hours. And in the classroom, I will be discussing about the PYQ of the topic. In this printout, you will not have PYQs. In the classroom, you will be having PYQs discussion on the same topic. So here we will be understanding the pattern of the question paper. Here we will be understanding the authenticity or on what basis the UPSC will be asking the questions, or why UPSC will choose that question. And for every topic, I am going to discuss why it is in the news, why that particular topic is in the news. If it is in the news, then that means that compulsory it is an expected question for prelims 2026. So we will start the session. So first topic which is in the news is privileges, parliamentary privileges. What happened in the parliamentary privileges? There was an issue with respect to Rahul Gandhi. What happened with respect to Rahul Gandhi? Why it is in the news, parliamentary privileges? Rahul Gandhi told that all Modis, Lalit Modi, Nirva Modi, Narendra Modi, all Modis are thieves. Why only all Modis are thieves? So this was being told by Rahul Gandhi. So in this context, the opposition party had asked him to be disqualified, as well as two topics are there under this: disqualification of Rahul Gandhi and is also a privilege. So he will not get privilege. He will not get any criminal immunity. So hence on these two contexts, we are going to discuss about the parliamentary privileges and how MPs and MLAs will be disqualified. So Rahul Gandhi, the opposition leader, under him a criminal case was being filed. But under this criminal case, whether he will be disqualified or not, whether he will be enjoying the immunity, whether he will be enjoying the privileges or not, what are all the privileges which are there with the MPs, what are all the privileges which are there for MLAs, and if you want to disqualify an MP, if you want to disqualify an MLA, what are the provisions which are left with. So this we are going to discuss. So Article 105 talks about parliamentary privileges. Article 105 talks about parliamentary privileges. So what happened? Two contexts are there. First context is Rahul Gandhi. Second context, if you remember, Moitra Mahua, there is an MP. She was being accused that she is taking money and asking the questions. She is taking the money and asking the questions in the parliament. So these two issues are there. First issue is about Rahul Gandhi. Second issue is a Trinamool Congress West Bengal MP. She was being accused that you are asking the questions in the parliament by taking the money. And by taking the money, you are asking the questions, which is also a bribe. So in this context, the Supreme Court of India gave judgment. In 2024 and 2025, mainly in 2024, the Supreme Court gave the judgment under the Sita Sorin versus Union of India. Sita Sorin versus Union of India. The Supreme Court told that any parliamentarian taking bribe, in the parliament for the functioning of the parliament is also called as criminal conduct. Earlier what happened? In 1992, there was a judgment on P.V. Narasimha Rao, 1992. In that, the same Supreme Court told that bribery cannot be a criminal conduct for parliamentarians. 1992, P.V. Narasimha Rao case, same Supreme Court told that bribery in parliament for parliament proceedings is not a criminal conduct. But in 2024, the same Supreme Court in Sita Sorin case explained that or told that for parliamentary procedure or in the parliament, if you are taking any bribe for the sake of parliamentary procedure, it is a criminal conduct. So anything which is a criminal conduct is subjected to disqualification. So that is what which has been told. In 2024, the Supreme Court in Sita Sorin versus Union of India case held that bribery of MPs, MLAs is not protected under parliamentary privileges. Means they are protected under parliamentary privileges earlier. Now they are not protected under parliamentary privileges. When they are not protected under parliamentary privileges, what will happen? They will be filed under, they will be sued under criminal conduct. They will be sued under criminal misconduct. Means what? Earlier, if we take bribe in the parliament, if we take bribe for the parliamentary procedure, it was been immune under what? Parliamentary privileges. It was immune under what? Parliamentary privileges. Now what? If any MP or MLA takes a bribe, they will not be immune under parliamentary privileges. So hence, earlier, bribery of a parliamentarian was immune. Now, bribery by a parliamentarian is not under immune, not under parliamentary privileges. Means what? It is a criminal misconduct. If it is a criminal misconduct, what will happen? He will be disqualified. That is the reason. So recently, we can expect a question like this. Bribery of a parliamentarian is a parliamentary privilege or not? Before 2024, it's a parliamentary privilege. After 2024, it is not a parliamentary privilege. Overruled 1998 judgment of P.V. Narasimha Rao and State of Andhra Pradesh. So, hence, in 1998 judgment, P.V. Narasimha Rao case, what the Supreme Court told, it is a parliamentary privilege. But now it is not a parliamentary privilege. If it is not a parliamentary privilege, what will happen? It will be under misconduct, criminal misconduct. If it is a criminal misconduct, what will happen? They will be disqualified. There is high chance of getting disqualification. Hence, Mahua Moitra case as well as Rahul Gandhi issue. Under these two issues, this parliamentary privileges now will be, bribery is also not under parliamentary privileges. So, what are all the sources? Now, this is the background. So, you should know about privileges. You should know about parliamentary privileges. So, what is parliamentary privileges, sir? Parliamentary privileges means mainly it is given for the parliamentarians as a privilege so that they will be functioning independently. They will be functioning autonomously. They will not bend for any political party. They will not bend for any bribe or they will not bend for any lure. They will be working unbiased. For that purpose, Parliament had created what? Privileges. So, what are the sources for these privileges? The UPSC can ask this. What are the sources for these privileges? There are 5 sources, means where the privileges are present. Where the privileges are present, in 5 sources the privileges are present. Number 1, the privileges are present in Constitution of India. It is present under Constitution of India. Under which article? 105. There are laws. There can be a law. There can be a law. Earlier in British times, British parliamentary laws were been there. There can be a law. There can be house rules, conduct of business rules. There can be conventions. There can be conventions. Like for example, if you are going into the parliament, there is a convention that man should not carry more than 10,000 rupees cash. Every parliamentarian should not carry more than 10,000 rupees cash. Inside there are some conventions. This is what? Convention. And judicial interpretation. So, for any parliamentary privileges, there are 5 sources. UPSC Prelims, privileges in the news. So, what are the sources for parliamentary privileges? There are 5 sources for parliamentary privileges. First is Constitution itself. Second is law. Third is house rules, conduct of business rules. It is called as house rules or conduct of business rules. Fourth is conventions. Fifth is judicial interpretation. So, these are the 5 sources for the parliamentary privileges. One question we can expect here under parliamentary privileges. What are the sources for the parliamentary privileges? What are the sources for the privileges enjoyed by the parliamentarians? So, there are two privileges are there. There are 2 privileges. One is called a civil privilege, which is called a civil immunity. Civil immunity. Other is called as criminal immunity. One is called as civil immunity, other is called as criminal immunity. Any parliamentarian will not enjoy any privilege under criminal action. if he does any criminal action, like he does a murder or a sexual assault or under POCSO, if any criminal activity is being done by parliamentarian, he will not be immune. So there is no absolute immunity, means he will be filed. For what cases? Criminal cases. But for civil cases, before the session of the House, 40 days, during the session of the House, after the session of the House, 40 days. So these many days, he cannot be sued, he cannot be filed under civil cases. So before 40 days of the House, during the session of the House, after the session of the House, 40 days, these many days, he will be immune from what cases? Civil cases, privilege. So atani meeda a case has been filed on him, he took some property and he is not paying back, civil case. Still he will not be filed FIR till he complete 40 days of parliamentary session. After completion of 40 days of parliamentary session only, he will be sued. So we have two. So for any parliamentary privilege got misused, or he didn't use, or he didn't have parliamentary privilege, but he did some civil wrong, he did some criminal wrong, then who will give the permission? For the Lok Sabha, Speaker will give the permission to sue him. For Rajya Sabha, Vice President means the Chairman of the Council of States, Rajya Sabha will give the permission. For the ML Legislative Assembly, he will be giving the permission. The Speaker will be giving the permission. So who will be giving the permission for filing the suit? Speaker. Speaker of the Lok Sabha, Chairman of the Rajya Sabha, Speaker of the Legislative Assembly, Chairman of the Legislative Council. So these are the basics or static things with respect to what? Parliamentary privileges. So what are parliamentary privileges? There are some privileges given. There are some, for example, I have a privilege. What privilege I have? I have given privilege to control you in the classroom, not outside, in the classroom, so that I can run the classroom. I can run the classroom properly. That is my privilege. That is my privilege. In this context, if any person is disturbing the class, I have the privilege to scold him. I have the privilege to send him out. He cannot sue me. He cannot sue me. Why? Because my duty is to run the classroom. That is called as privilege. Similarly, the parliamentarians have some privileges. For what purpose? To maintain independence, to work autonomously, to don't bend, to don't have any unbiased, to don't have any biased activity. These parliamentary privileges are there. So what are the sources for these parliamentary privileges? 5 sources: Constitution of India, laws, conventions, rules, and judicial interpretations. So for 2 cases, we will be having immunity: civil and criminal. Criminal, no immunity at all. Civil, we have 40 days before the duration of the House, and 40 days after the duration of the House. If the parliamentary privilege has been violated, for example, I am speaking properly in the parliament, I am speaking, I'm an opposition leader, I am speaking properly in the parliament, one ruling party member came and beat me. So my privilege has been violated. Now Speaker will be having the power to sue him, to take action on him. Why? Because my privilege got misused or violated. That is what. Then who will be taking the action? Speaker will be taking the action, or Chairman of Rajya Sabha will be taking the action, or Speaker of Legislative Assembly will be taking the action, or Chairman of Legislative Council. So for what purpose these privileges are there? To ensure independence and independence, free debate without fear of courts. No one should interfere. So absolute freedom of speech in parliament is absolute. Whatever he wants, he can speak. Absolute. No one can control. Article 19, not subject to Article 19, means Article 19 is having what? There are some limitations. Article 19 is having some limitation. What are the limitations under Article right to speech? What are Article 19? Speech, association, assembly, movement. Trade is removed, no? Sasuma. Residence, movement, profession, MRP. How we have to remember Article 19? Sasuma, MRP. Speech, assembly, association, movement, residence, profession. So, speech is not absolute. Everything is subjected to some limitations. But privileges, not subject to Article 19, means whatever they want, they can speak. Immunity from what? Protection from speech, protection from vote, protection committee work. Any work they can do as it is, no one can stop. Anything they can speak, no one can stop. Whatever they wish, they can vote. They are immune. They are not protected for what? Bribery. They are not protected for what? Criminal acts. Earlier, bribery was not there. Why? Because bribery was being considered civil case. Now what we did? Bribery came under criminal. That is the reason it is not under immunity. Means what? You should get it out. Sir, then PV Narasimha Rao case, bribe is wrong thing, no sir. Then why Supreme Court gave immunity? At that time, we thought bribery is a civil case. But now, we put bribery in criminal case. So, it is not subjected to privilege. It is not subjected to immunity. Now, he can be sued under what? Criminal antecedents. Other privileges, House of Commons, like suspension, expulsion, go out from the session, imprisonment, applies to who? Ministers and Attorney General of India. Means Attorney General of India is also subjected to have privileges, not being an MP. Minister also is subjected to be privileged, to have privilege, not being a member of Parliament. A minister can be appointed without being an MP or not. For how many months? That is, so every MP is having privilege. Every MP is having privilege. Then why specifically I discussed applies to ministers and Attorney General? Why? Because these both are not being ministers. Sorry, these both are not being MPs. For example, minister. A person can become a minister without being MP. For how many months? 6 months. But all the privileges only for MPs. All the privileges only for MPs. But minister is also having privilege, not being an MP for a minimum of 6 months. So, for 6 months not being an MP but appointed as a minister, still he will enjoy privileges. Attorney General Officer is not an MP but still he is enjoying privileges. See the PYQ. With reference to parliamentary privileges, consider the following statement, 2023 question. You don't have PYQ, here only you have. The privilege of freedom of speech in Parliament is mentioned under Article 105 of the Indian Constitution. See, he had freedom of speech. Whatever he wants, he can speak. He is not under the control of Article 19, he is under the control of 105. So, he is having absolute freedom of speech. Whether we are having absolute speech or parliamentarians in Parliament is having absolute speech freedom. Parliamentarians in Parliament is having absolute freedom. We don't have absolute freedom. Citizens don't enjoy absolute freedom. But parliamentarians also don't enjoy absolute freedom. They will enjoy absolute freedom only in because of which article? 105. Correct statement. Are you getting my point? Second, the parliamentary privileges are extended to both President and Attorney General. President or ministers? Ministers. It's wrong statement. It's not President, it is who? Ministers. At present, there is no special law in India. Yes, true. See, it was mentioned that any law can be made. Any law can be made to give privileges. But as of now, no law was being made to give more privileges. So, this is also correct. I am not bothered about this. So, how the questions were being formed? See, 5 sources are there. First source is Constitution. Anyhow, it is there in the Constitution, 105. Second is their law. But they mentioned under Article 105 that there are privileges. Article 105 clause 2 will tell that Parliament have the power to make a law to give more privileges. But in reality, up to now, no law was being made. Supreme Court. Privileges exist, but they are subjected to Constitution, judicial review. PV Narasimha Rao case, bribery linked to vote was protected. Why? At that time, bribery was being seen as what? Civil. Now it is seen as what? Civil. Are you getting my point? Now, hence, it is a violation of privilege. Yet, it is a privilege. Parliament can expel members. Judicial review is there. Sita Sorin, bribery not protected. Constitution will give privileges, but bribery is not protected under which judgment? Sita Sorin versus Union of India, year 2024. Speaker, Who is the power to decide? Privilege, speaker. Refer to privilege committee, maintains order. In Rajya Sabha, who? Chairman. In legislative assembly, whom? Speaker. In legislative council, who? Chairman. Prelims. Article 105 applies to Parliament. Article 194 applies to. See how to remember. There are some things which you have to remember. Parliament, state legislature. Add 89. You see, you check. Now only we will check. 105 plus 89 is equal to 194. You will see others also in future. Center plus 89 is equal to state. You see, 105 is Parliament plus 89. State legislature is 194. We will see other articles also. Remember this, plus 89. Privileges not codified yet, yes or no? Whether any law is been made? No. Codified means whether any law is been made. No law is been made. Judicial review is available. Everything is subjected to judicial review. Applies to Attorney General. These are prelims. Little bit confusing. So this is prelims high yielding areas. So any question on privileges, we should be in a position to answer any question on privileges. So there are two privileges. One is civil privileges, other is criminal privileges. So civil privileges are being given immunity 40 days before, duration and after. Earlier bribery was a civil, now it is a criminal. Now Sita Soren case told that bribery is also a criminal offence. Hence they don't enjoy any privilege, immunity. They don't enjoy any privilege. What are the sources? Constitution, law, rules of house, convention and judicial interpretation. Everything, all the privileges are subjected to judicial review. All the MPs plus ministers, including Prime Minister also. Ministers means Prime Minister also. Whether Prime Minister can be appointed without being an MP? Yes, Manmohan Singh. In 2014, he is not a member of Parliament. He is not a Lok Sabha MP, he is not a Rajya Sabha MP. He was made Prime Minister, then he was being made Rajya Sabha MP. So it can be any minister, including Prime Minister plus Attorney General. They are not being a member of Parliament, still enjoy privileges. Fifth schedule. Now it is in the news. Fifth schedule of the Constitution. Fifth schedule, what it discuss about? Fifth schedule of the Constitution come under Article 244 Clause 1. Fifth schedule of the Constitution come under 244 Clause 1. Why it is in the news? 2025 Ministry of Tribal Affairs 2025 Ministry of Tribal Affairs annual report very clearly told that at the time of Constitution 1950, what are all the schedule areas are there? Today also same schedule areas are there. Today also same schedule areas are there. There is no expansion, there is no reduction. There is no increase, there is no decrease. Some change should be there, no? Either area should be reduced or the area should be increased. Nothing has been done. It shows that the parliamentarians or the government of the day is not at all bothered about schedule area. So it's a grave thing. Either area should be reduced or the area should be increased. Nothing is happening. So the government attitude towards the welfare and the development of scheduled 5 areas is zero, was being told by Ministry of Tribal Affairs report in 2025. Hence it is in the news. So scheduled areas comes under Article 244 Clause 1. 10 states are there under scheduled 5 areas. Scheduled 5 areas means except Northeast India, the tribal pockets, very important, remember this. There is no percentage given by the Constitution. It clearly told that preponderance of tribal population. In the exam, if he gives percentage, then it is wrong statement. There is no specific percentage. It told what? Preponderance of tribal population in the pockets. Preponderance of tribal population in the pockets where the tribal population is significantly more when compared to surrounding area. That area will be identified as what? Scheduled 5 area in mainstream India. So in India we are having 10 scheduled area states. 10 scheduled area states. Those are Andhra Pradesh, Telangana. Those are Chhattisgarh, Jharkhand. Those are Odisha, Madhya Pradesh. How to remember, sir? Andhra Pradesh and Telangana once upon a time 1. Chhattisgarh, Madhya Pradesh once upon a time 1. Next, tribal district means we know tribals means Odisha and Jharkhand. Then contiguous. Maharashtra contiguous with Gujarat. Gujarat contiguous with Rajasthan. Maharashtra, Gujarat, Rajasthan, contiguous, joined. And one extra which you have to remember is Himachal Pradesh. So you know that earlier, Andhra Pradesh, Telangana is one state. Madhya Pradesh, Chhattisgarh is one state. Tribal states means Jharkhand and Odisha. And contiguous states are Maharashtra, Gujarat and Rajasthan. One extra state which you have to remember is Himachal Pradesh. These are the 10 scheduled 5 areas under Article 244 Clause 1. See the question. How they asked the question in 2023. With reference to scheduled areas, consider the following statements. Within a state, the notification of an area as a scheduled area takes place through an order of the President. Yes, President. President will have the power. The largest administrative unit forming the scheduled area is a district and the lowest is the cluster of villages which is called as block. Correct. The Chief Minister of the concerned states are required to submit. Chief Minister or Governor? Governor. See, how many of the above given statements are correct? Earlier question also, how many of the given statements are correct? My dear students, few people who believes in shortcuts, who believes some magic will happen, they are depending on elimination methods. Elimination methods will work only for 5% of the questions, not all the questions. Now you tell me, how many, if 1, 2, 2, 3, here you can use elimination technique. How many of the given statements are correct? You should know it. If 1, 2, 3 is wrong means okay, then 2 is correct also, it is wrong only. 1, 2, if 1 is wrong, 1, 2 is given, then it is wrong. This we can do. But UPSC is asking like this, no, only 1 is correct, 2 is correct or 3 are correct. Then here what is the answer? If you know, it is correct. If you don't know, so don't believe in elimination methods. Don't believe in shortcuts. There is no shortcuts. Content, we should develop the content. Yes, once upon a time, when this type of questions were not there before 2022, elimination methods worked up to some extent. If you see 2023, 2024, 2025, elimination methods did not work at all. We have to focus on content. When you focus on content, when you understand the content, automatically you will only develop the shortcuts. But directly if you remember the shortcuts like mathematics, it won't happen. So schedule areas declared by whom? President. What are the president power? Increase, decrease, alter, rescind earlier notification, cancel earlier notification. So who is having the power to increase the area, decrease the area, alter the boundaries? President. Role of governor. He will submit annual report to the president regarding the administration of scheduled areas, make regulation for peace and good governance in scheduled areas. So it is not the chief minister who will submit the report. Who is the person submit the report? Governor. And who is the person who will be increasing and decreasing, altering the boundaries? President of scheduled 5 areas. Governor. Transfer of tribal land to non-tribals. What are the powers of governor? He is the only person to transfer the land of tribal to non-tribal. He is having the power. President doesn't have, chief minister doesn't have, council of minister doesn't have. Who is having the power to transfer the land from tribals to non-tribals? Governor will be having the power. That too, it is very clearly mentioned. In the rarest of the rare situations only, the tribal lands can be converted to non-tribals. Anni situations lo kaadu, only in the rarest of the rare situations only the tribal lands. Means what? When you read, why I mentioned this point, when you read tribal lands cannot be converted to non-tribals, tribal lands cannot be converted to non-tribals, like this we will be reading. But there is one exception. The exception is governor. Only, not president also. Governor will be having the power to transfer the tribal lands to non-tribals. Money lending activities, administration of villages. We can expect this question. What are the powers of governor in the scheduled areas? What are the powers of governor in scheduled areas? First power is what? First power is transfer of land from agriculture, from tribal to non-tribal. Second is what? Money lending activities. Third is what? It is there in the Constitution under Article 244 Clause 1G. These three provisions are there. These three provisions, who is having the power? Governor is having. You should know, yes, 100%. If you become an IAS officer and you are posted in Meghalaya, and there is a case came whereby there is a need to regulate money lender, then with whom you have to talk? Whom you have to request? That you should know. You should request whom? Governor. Regulations, and this regulations require whose assent? President. See, understand that. President cannot regulate directly. President can regulate it by passing through governor. But once the governor had made a regulation, it should get approval from president. Without getting approval from president, it is null and void. So, two procedures are there. One is governor will do it and it should get approval from President of India. And there will be a tribal advisory council. There will be a tribal advisory council in Schedule 5 areas. Tribal advisory council in Schedule 5 areas. This we are discussing about Schedule 5 areas. 20 members will be there in the Schedule 5 areas. In that 20 members, 3/4 member should be ST MLAs. So, for every state in the Schedule 5 areas, 20 members will be there in a tribal advisory council. In this tribal advisory council, who will be giving recommendations to the governor, 3/4 member should be whom? ST MLAs. What they do? They advise governor, they work for the welfare of STs, the advancement of tribal communities. Parliamentary or union oversight. Parliament can make laws regarding scheduled areas and tribal welfare. Union government can issue direction to states. This creates strong central oversight in tribal administration. So, these are the functions. So, first we are understanding Schedule 5 area, Article 244(1), 10 states are there, and mainly the power is vested in governor. Governor is having the power to transfer the tribal land to non-tribal and money lenders and administration of Schedule 5 areas. Third, it will be finalized only after approval from President. So, President doesn't have the power. Who is having the power? Governor. Federal structure and state autonomy. The 5th schedule creates asymmetrical federalism. Why? Because in your syllabus, federalism is there. Federal features. President decides schedule area boundaries. Little bit deep. Now, it is becoming an issue. What? Few states are asking, for example, I will tell you, Khammam district of Telangana, Visakhapatnam district of Andhra Pradesh. They are requesting letters to the president. Visakhapatnam, very big city, Vizag. 50 kilometers away from Vizag, there is Scheduled 5 area. Up to Scheduled 5 area, a lot of real estate companies came and started constructing big villas. But there is a threshold line. They are not crossing threshold line. Why? Because from there what started? Scheduled 5 area. Now, the state government is asking that, sir, please reduce some Scheduled 5 area so that the people want to have their homes. Real estate is growing. Development is happening. But you did not change the boundaries of Scheduled 5 areas. We are stopping development at the junction. So, please change the Scheduled 5 areas. So, this type of recommendations when going to the parliament, going to the president, there is asymmetry. Tamil Nadu also. In Kerala also. Such type of issues are there. Mainly this is there in Andhra Pradesh and Telangana. So, when this Telangana state is asking Congress government, there the BJP government, they are not accepting it. For example, Khammam district, where the development is just beside the Khammam district, there is Schedule 5 area. Khammam city, Schedule 5 area. They are asking, but central government is not bothered. So, there is a rupture between state government and central government. So, Scheduled 5 area, the geographical area is also one of the contention between the center and the state. Union government can issue directions to states. Governor exercises discretionary powers. Governor may modify or suspend state laws in scheduled areas. Thus, the governor often acts as an agent of the union, leading debates of state autonomy. So, there are issues with respect to Scheduled 5 area. See, what are the issues between the center and the state means? We will only think financial issues. We will think president's rule. Scheduled 5 area is also one of the issue of contention between center and state. Scheduled 5 area is also one of the issue of contention between center and state. So the Schedule 5 is also more probable topic which is responsible for asymmetrical relationship between center and state. And 30 years of PESA Act. Why it is in the news? 1996, 2006, 2016, 2026. How many years happened PESA Act? 30 years. What is PESA Act? Panchayati Raj extension to scheduled areas. It's a PYQ also. They asked about PESA Act earlier. Panchayati Raj extension to scheduled areas. So what happened? In 1992, when 73rd Constitutional Amendment Act was been made, Panchayati Raj institution was been made, the parliament thought that we will not apply to Schedule 5 areas. Why? Because they have their own tribal advisory council, they have their own way of administration. We will not put Panchayati Raj institution in Schedule 5 areas. So Schedule 5 area was been exempted from Panchayati Raj institution. Then 1993-1994, by seeing the success of Panchayati Raj institution, the schedule area people are also started asking for grassroots level democracy. Please give us Panchayati Raj institution. Then the government of India understood and made a legislation. And the legislation is called as what? Panchayati Raj extension to schedule areas. Now this Gram Swaraj, Gram Panchayat, the 73rd Constitutional Amendment Act also will be applied to Scheduled 5 areas. So PESA Act completed how many years by 2026? 30 years. It established Grama Sabhas in every scheduled area village. First point. Established Grama Sabhas in every Scheduled 5 area village. First point. Second point. Any land acquisition need to be happened in Scheduled 5 area. Remember this. Any land acquisition need to be happened in Scheduled 5 area with approval from governor also. They should consult whom? Grama Sabha. But it is only consultation, it is not approval. It is only consultation but not approval. Consultation of Grama Sabha at the time of land acquisition. What are the provisions of PESA Act? First provision is what? First provision is what? First, there will be a Grama Sabha. Second, consultation of Grama Sabha at the time of land acquisition. Grama Sabha control over minor forest. What is minor forest produce? Minor honey, lac, resins. Not only minor forest produce, minor minerals also, both. Minor minerals are what? Sand. Minor minerals are what? Sand. Who is the owner of minor minerals? Grama Sabha. Who told this? PESA Act. Third point. Fourth point. Protection of traditional tribal institutions. Implementation remains weak in many states. These are the 4 points which are there in PESA Act. What are the main provisions of PESA Act? Number 1, Grama Sabha. Number 2, consultation of Grama Sabha. Number 3, minor forest produce and minor minerals also. Minor forest produce and minor minerals also. 4th, protection of traditional tribal institutions. Sometimes we can expect this question. What are the important or what are the committees constituted by the government of India for STs and scheduled areas? One is Debar Commission. Other is Buriye Commission. Exclusive for not for ST, only for scheduled area. Remember this. Exclusive for scheduled areas, it is what? Debar Commission and Buriye Committee. What are the committees constituted by the government of India for exclusive development of Scheduled 5 areas is Debar Commission, Buriye Committee. First major commission, decentralized governance in tribal areas led to enactment of PESA Act. PESA Act. Sometimes. PESA Act was been legislated in the year 1996 on the recommendations of which committee? Buriye Committee. On the recommendations of which committee? For example, I will tell you. Child Labor Prohibition and Regulation Act 1986. Again, we have another Child Labor Regulation and Welfare Amendment Act 2016. But first law is Child Labor Regulation and Prohibition Act 1986. On which, this is a PYQ. Based on which committee recommendation Child Labor Prohibition and Regulation Act 1986 was been made? Gurupada Swami Committee. On the same lines, Scheduled 5 area, PESA Act was been made on the recommendations of which committee? Buriye Committee. Then what happened? Manipur. Next thing which happened is Manipur. What happened in Manipur? Polity. Subject is what? Polity. So you should answer mean polity only. President's rule. President's rule was imposed in Manipur instead of BJP government there. Are you getting my point? If Congress government is there, if they had imposed president rule means something important. But BJP government is there, still they imposed president rule, more important. So president's rule comes under Article 356. So their own government was there, but still they imposed president's rule. If they impose president's rule, what will happen? They will get negativity. In spite of the negativity, central government has imposed president's rule. In Manipur, and extended now also, today also. Article 365 provides for president's rule in state when the constitutional machinery fails. Article 355, Union must ensure the states are governed according to the constitution. Article 355 tells that Union should ensure that the state should function according to the provisions of the constitution. Article 356 tells that if any state parliament or any state legislature is not functioning according to the provisions of the constitution, then what will be applied? 356 and 355. So see, understand, very brief. Only Article 356 is not sufficient to apply president's rule. Article 356 and 355 both should be ensured. Both should be enforced. Then only we can apply president's rule. Article 356 gives the reasoning that state or that part of the state is not functioning according to the constitutional system or the constitutional machinery has been failed, number one. Number two, then as per Article 355, the Union government is having the power to check whether the states are functioning according to the provisions of the constitution or not. Hence, we are enforcing Article. Question. Article 356 is sufficient to impose president's rule. Article 356 and 355 both should enforce for president's rule. Both should be enforced. One option will be Article 356. Those who read Lashubha, they come to a conclusion that it is only Article 356. So it is not only Article 356, 356 and 355. President's rule. You know the procedure. On recommendation of governor of the constitutional failure, if a state legislature is unable to function according to the provisions of the constitution, if the union feels, these are the two reasons to impose president's rule in state. Executive. Who will be taking care about the state now? Central government. Who will be having this executive power? Center. Parliament role. Now, every such proclamation get parliament approval within 2 months. So, if a president's rule is imposed, within how many days or how many months we have to get the approval from the parliament from president's rule? 2 months. A maximum of 3 years by approval by parliament for every 6 months. So, initially president's rule is imposed. Within 2 months we should get parliament's approval within 2 months. Then after for every 6 months we have to get parliament's approval. Then up to how much time? Maximum up to 3 years. Then what, sir? After 3 years, the president will ask the Election Commission of India whether any chance to conduct elections. Then Election Commission will submit a report to the president. Sir, now also there is no chance to conduct the elections. Then only they can extend president's rule. But for 3 years, there is no need for getting report from Election Commission of India. After 3 years only, they will ask the Election Commission of India whether we can conduct elections properly. If they say yes, then they will stop. President's rule and go for elections. If they want to remove the President's rule, President just by writing he can remove the President's rule. There is no need for parliamentary approval. 44th Constitutional Amendment Act 1978, President's rule can be imposed in any state beyond 1 year unless a proclamation of national emergency in operation, the Election Commission certifies that the continuation is genuine. Then only they can. So, President's rule was imposed recently in which state? Manipur. President's rules need to be applied means which are the articles to be enforced? 356 and 355, both together. After the proclamation of President's rule, within how many months we need to get Parliament's approval? 2 months. For every 6 months we need to get approval, maximum up to 3 years. But 44th Constitutional Amendment Act brought one change, that the proclamation of emergency can be stopped just by President's signature. No need for approval again from Parliament. Number 2, if the proclamation need to be continued beyond 1 year after 44th Constitutional Amendment Act, they should get approval from again from whom? Election Commission of India. These are the provisions for, yes. When state government cannot function according to the constitution, governor submits a report. When hung assembly, loss of majority, breakdown of law and order, political instability. Breakdown of law and order when? Which article? 365. Article 356 is what? President's rule will be imposed. Article 355, union government should ensure that the state should function according to the constitutional provisions. Article 365 talks about what? If there is any law and order breakdown, then the president will be having the power to impose proper law and order. At that time, they can go for President's rule. So, 356, 355, 365. These are the 3 articles which are talking with respect to what? President's rule. 365 is only for law and order. 356 and 355 is for constitutional machinery. Breakdown of constitutional machinery. You know that State Council of Ministers is dismissed. State Council of Ministers is dismissed. Consequences of President's rule. First, State Council of Ministers will be dismissed. Governor administers the state behalf of the President. State Legislative Assembly will not be there, either suspended or dissolved. What are the consequences of President's rule? First consequence will be State Council of Ministers will be dismissed. State Legislature can be suspended or dissolved. It is up to the discretion of Central Parliament. So, what are the consequences of President's rule? Number 1, State Council of Ministers will be dismissed. State Legislature either will be suspended or will be dissolved. If it is dissolved, they have to go for elections. If it is suspended, again they will be reinitiated. And every President's rule is subjected to judicial review. Every President's rule is subjected to judicial review. Manipur issue also went to judicial review. The Supreme Court of India very clearly told that there is law and order problem in Manipur. So Article 365 was being enforced. Under Article 365, law and order was not good. So President's rule is appropriate, not an issue. See, before 44, after 3 years, they have to go for election commission. But after 44, after 1 year only they have to go for report from election commission. Original constitution told that for 3 years, after 3 years they have to go for election commission. But 44th Constitutional Amendment Act told that for 3 years they can go, but after 1 year, for every 1 year they have to go to get the approval from election commission. For every 1 year, for every 1 year, for every 1 year. Means what? Before 44, after every 3 years, they have to get approval from Election Commission of India. After 44, after every year, we have to get approval from Election Commission. Before 44 Constitutional Amendment Act, after 44 Constitutional Amendment Act. So mainly what is happening, there is again federalism question is there, that Wherever the state government is different from the central government, you are going for president's rule. So federal feature is getting impacted. You are imposing president's rule according to your wish, according to your whims and fancies. So there is a tussle between the center and the states with respect to imposition of president's rule. This is very important. For 40 years, how many times, more than how many times the president's rule was been imposed? 90 times. Supreme Court setting timeline for president on bills. Now what happened? You know that another current affair, that state governor is not giving assent to the bills passed by the state legislature. State governor is not giving assent to the bills passed by the state legislature. Whether it's constitutionally correct or not, whether constitutionally appropriate or not, this is the issue which is there. The Supreme Court of India recently came and gave two timelines to decide whether to give assent or to withhold the assent. The time given is 1 month and 3 months. The time given is 1 month and 3 months. So the issue, as we know, that Ravi, governor of Tamil Nadu, the governor of Kerala, they are not giving their assent to the bills passed by the state legislature of Kerala and Tamil Nadu and West Bengal. These are the three states which are issues. So what the Supreme Court told, how much time they gave, is also important. See, timeline set by Supreme Court. If Council of Ministers recommended within 1 month, state legislature passed. State legislature passed. Now the bill is with governor. If State Council of Ministers, again they advise the governor, sir, governor, can you please pass the bill or take some action? Then how much time he will have? 1 month. If a bill passes from state legislature and with the governor, State Council of Ministers did not give their advice, then how much time? 3 months. Are you getting my point? Supreme Court of India set a deadline for the bills coming to the governor from the state legislature with advice of Council of Ministers, without the advice of Council of Ministers. What is this? It is passed, went to the governor. Now specially Council of Ministers are advising with a letter. Can you look into it? Then how much time? 1 month. If Council of Ministers are not writing a letter, then how much time? 3 months. These are the deadlines which are being set by the President, by the Supreme Court to the governor with respect to take action. Edo action. I'm not telling to give assent. I'm not asking to withhold. I'm not asking you to send back. I'm not asking you to refer to President. You do something, but don't have a pocket veto. What they are doing? They are keeping in their pocket indefinitely. So what is happening? The bill is not getting passed. The bill is not getting withdrawn. The bill is not getting returned back. The bill is not referred to the President. It is just under suspension mode. That particular veto is called as what? Pocket veto. In order to avoid pocket veto, prelims point of view, Supreme Court recently gave judgment to avoid which type of veto? Absolute veto, suspensive veto, pocket veto, none of them. Pocket veto. Give or withhold the assent, reserve the bill for the consideration of the President, assent to the bill reconsidered by the state legislature, whatever it may be. What is important? If with the advice of the Council of Ministers, how much time you are given? 4 conditions are there. Give assent, withhold the assent, refer to the President, or refer back to the legislature. These are the 4 conditions which are prevailing. So if it is re-asked by the Council of Ministers with advice in how much time? 1 month. Without the Council of Ministers advice, how much time? 3 months. Under Article 142. 143 what? President will be asking the advice of Supreme Court. Article 143 what? President will be asking the advice of Supreme Court on the issues, whatever may be. For example, simultaneous elections is there. I want to have a simultaneous elections, whether it's constitutionally valid or not. Then whether it will be, judiciary will tell unconstitutional or not, I have a doubt. Then I will go and ask for whom? Supreme Court. Under which article? 143. Before that, 142. The court relied on the principle to stress that constitutional process cannot be indefinitely stalled. Supreme Court to pass any order necessary to do complete justice. Sometimes Supreme Court will be having the power to act. Comes under Article 142. Under Article 142, to act, sumoto, to act sumoto by its own. Under which article? 142. The Supreme Court gave judgment 1 month and 3 months. So this timeline was been fixed under which article of the Constitution? 142. So four powers he will be having: governor, give assent, withhold assent, return bill for reconsideration, or reserve the bill for president. So with respect to these 4 actions, 1 month and 3 months time was been fixed under which article? 142. If a bill is reserved, the president may give assent or withhold assent. President doesn't have pocket veto. Only who have pocket veto with respect to the bills coming from state? Governor. The president either pass it or withhold it. Direct governor to return the bill to the legislature. The Constitution does not specify any time limit. Supreme Court in hearing, the Supreme Court stated governors and presidents cannot sit indefinitely on bills. Constitutional powers must be exercised within a reasonable time. The court suggests that decision should normally be taken within about 3 months. So hence, for state legislature, it put time with advice of Council of Ministers 1 month, without the advice of Council of Ministers 3 months for governor, and for the president, with advice or without advice 3 months. Did you got the difference? Yes, this you know. Now, next topic, which is called as 6th schedule of the Constitution. Yes. Why it is in the news? Ladakh is asking for 6th schedule. 5th schedule, why is in the news? Because no increase, no decrease of schedule area under the report of Ministry of Tribal Affairs. Now, Ladakh is asking for what? See. We know that 2019 Article 370 was been abrogated. Article 370 was been abrogated, and Jammu and Kashmir was been divided into 2 union territories. One is union territory with legislature, other is union territory without legislature. Union territory with legislature is Jammu and Kashmir, union territory without legislature is Ladakh. So hence from that day onwards there were issues. At least up to now. We used to have representatives in Jammu and Kashmir state legislature. But now you made Ladakh as a union territory but without any legislature. Then what about our aspirations? What about our people aspirations? No problem. We are not bothered about it. Please add me as in Schedule 6. Add me as in Schedule 6. Wang Chung. Now comes who? Wang Chung. Today also is a current affair. Today also he is arrested. House arrest. So, Schedule 6. Mainstream India, tribal areas are called as Schedule 5. Tribal areas in Northeast India are called as Schedule 6. Tribal areas in mainstream are called as what? Schedule 5. Tribal areas in Northeast is called as Schedule 6. How many Schedule 6 areas are there? Assam, Meghalaya, Tripura, Mizoram. Now, what are the issues coming up? The issues are Article 244 Clause 2 very clearly mentioned that in Schedule 6 only those states will be added which are in Northeast India, but Ladakh is not located in Northeast India. First condition. So, to add them into the Schedule 6, we have to make a constitutional amendment to Article 244 Clause 2 and we have to remove Northeast and we have to add Northeast and North. So, this is a very big roadblock to add Ladakh in Schedule 6. Article 240 what? Assam, Meghalaya, Tripura and Mizoram. AMTM. So, this is very important. What are the powers of governor in Schedule 5 areas? Here, I will say a few things. Remember this. See, Schedule 5 and Schedule 6, every year compulsory expected question. Schedule 5 and Schedule 6. I will do complete revision of Schedule 5 and Schedule 6. Article 244 Clause 1 is Schedule 5. In mainstream India, the tribal districts where the tribal areas are located, that particular tribal states are being named as what? Schedule 5 states. In Northeast India, where the tribal people are significantly present, they are being named as Schedule 6, which is called as tribal areas. So, Schedule 5 is schedule areas, Schedule 6 is tribal areas. So, 10 states are there in Schedule 5 areas. What are the 10 states? Where the tribals are significantly present. In 10 states, the tribal people are significantly present, like Andhra Pradesh, Telangana, Chhattisgarh, Madhya Pradesh, Jharkhand, Odisha, Maharashtra, Gujarat, Rajasthan, Himachal Pradesh. In this every Scheduled 5 area, the governor is given more power. In every Scheduled 5 state, there will be a tribal advisory council. In every tribal advisory council, 20 members will be there. In that, 3/4 member will be that state's ST MLAs. Means out of 20, 15 will be ST MLAs, remaining can be others. This tribal advisory councils will be recommending to the governor on 3 issues. Number 1, transfer of, the powers of governor is what? Transfer of tribal land to non-tribal. Number 2, money lenders. Number 3, administration. These regulations can be made by the governor on the recommendations of tribal advisory councils. But these regulations will become applicable if it is approved by president. One more extra power is there with governor in Schedule 5. Whatever the laws passed by the state legislature, he is working like gatekeeper, governor. Whatever the laws made by the state legislature, by default will be applicable in Scheduled 5 areas. But sometimes he will be using his exclusive power and he will be stopping the law to be passed. He work like gatekeeper. No. This legislation should not be applied to Scheduled 5 area. If this legislation is applied to Scheduled 5 area, they will be impacted badly. If the governor thinks, he can stop the bill to be applied in Scheduled 5 area. Schedule 6, mainly Northeast India. 4 states, Assam, Meghalaya, Tripura and Mizoram. There will be autonomous district councils. They are elected by the local people. Tribal advisory council is nominated. Autonomous district council is elected. Who is powerful, nominated or elected? Elected. There will be autonomous district councils for every tribal area. For every state, there will be tribal area. Assam, Meghalaya, Tripura, Mizoram. This tribal area will be regulated by which body? Autonomous district council. This autonomous district council is regulated by whom? Governor. Governor will be regulated by whom? President. Now these autonomous district councils are having powers on what? Land administration, on what? Forest management, on what? Customary laws, on what? Village administration, on what? Local taxation, on what? Cultural protection, on what? They can make laws on social customs and tribal traditions. On this, who is having power? Autonomous district councils. Now, here in Schedule 6 area, whatever the law is being made by the state legislature of Assam, Meghalaya, Tripura, Mizoram, by default will not be applicable in these states. All the times the governor will close the gate. It will not enter. If governor feels this law is useful for the tribal areas, then he will lift the gate. This will go and apply. Then again he will close. Then again this is also very good. Then again he will open the gate. Again it will be applicable. Here what happened in Schedule 5 area? By default all the times gate is open. Few times he will close it. But in Schedule 6 all the times the gate is closed. When he thinks, then he will open. That is the power of governor in Schedule 6 and Schedule 5. Whatever the legislation made by whatever the rules or the laws made by the autonomous district councils will be regulated by the governor and will be regulated by the president. Autonomous district council of Schedule 6 is elected. Tribal advisory council of Schedule 5 is nominated. Why Ladakh is asking for Schedule 6? They will have autonomy. This all will be applicable for them now. They can have their own land administration. Central government will not have say. Why Ladakh is asking for union territory? Why Ladakh is asking for Schedule 6? Because by the name of union territory, it is establishing military bases on the border of China. It is acquiring the villages of Ladakh. The central government is taking the resources of Ladakh. So if the Ladakh want to stop the central government from taking the resources of Ladakh, the best solution is what? Make it as a Schedule 6, a permanent solution. Permanent solution. Central government will not come now. Why? Because in Schedule 6, who is the powerful? Autonomous district councils. Governor will be having the power. On which aspects? Land, forest, customary, village administration, land, cultural production and social customs and protection of tribal land, safeguarding cultural identity, greater local autonomy, regulation of land ownership by outsiders, protection from rapid demographic change. Over 97% Ladakh population belongs to. Because of these reasons, they are asking for. Wang Chung was the person who was the forefront demanding Schedule 6 status for Ladakh. What are the existing? Ladakh Autonomous District Hill Development Council of Leh, Ladakh Autonomous Hill Development Council of Kargil. This council do not have any constitutional provisions like 6th schedule. Granting 6th schedule status to Ladakh raises questions. It is only for 6th schedule is only for northeastern states. Extending it out of northeast required what? Constitutional status. So we can expect about Ladakh. Being a civil service aspirant, the burning issue was 6 months back. Ladakh was on fire, very much fire. It was an opportunity for China to enter into the Ladakh. Why? Because Ladakh is on fire. Why they are on fire? They are asking for Schedule 6. Whether we can give Schedule 6 easily, people without knowledge, they said, let them give now. Anyhow, 97% people are their tribals. Then what will happen? Whose role will be reduced? Central government role will be reduced. And where it is located? Vulnerable area on the borders of China. Then defense forces cannot go, no. We cannot have air bases, we cannot have cantonments, we cannot have any arms and ammunition there, we cannot deploy our armored forces. Then our territory will be under threat. So the opinion of union government is correct only. But at the same time, tribals also should be protected. Then what we should do? We should strengthen already existing institutions like what? Ladakh, Autonomous Hill Development Council of Leh. Give them more power. We have to develop already existing institutions. That should be the solution. Compulsory is the expected question for mains. Ladakh is demanding for Union Schedule 6 area status, whether it's good or bad, to give it. No confidence motion. Speaker powers. Impartiality of speaker's removal motion. Recently, Speaker Om Birla, he was in news. No confidence motion for the removal of speaker. Hence, it is in the news. Then what is the procedure for removal of the speaker? Whether we have to remove the speaker or not. I am identifying the areas where we can expect a question. Speaker, very much issue speaker removal. Why? We are not bothered about why he was been asked to remove, rather than what is the procedure for removal of speaker. So, concerns have been raised regarding the impartiality of speakers in several legislatures, especially in matters such as anti-defection cases, delays in recognizing opposition, handling of removal notices. For example, I will tell you anti-defection cases. One classic case I will tell you. You have awareness or not, but I will tell you. There is an MLA in Station Ganpur of Warangal district called as Kadiyam Srihari. He elected from BRS ticket. He became MLA. Then the Congress told that we will give MP ticket to your daughter. We are the rulers. We became, by the time they won, we are the rulers now. We are the state government of Telangana state. So, if you become congressman, we will give ticket to your daughter and we will ensure that she will also win. We will give money, everything. Then he jumped. Now he is Congress. Daughter is anyhow Congress. Problem is with Kadiyam Srihari, who won by BRS ticket and working as congressman. Then violation of anti-defection. Violation of defect, he defected. People voted for him because he is a BRS man. But after winning, he jumped into Congress. So he cheated whom? People. He cheated whom? People. If the same person, if he would be in Congress, they would not vote him, maybe. So the person is in BRS, then they voted him. He became the power. After winning, he jumped to the party. Democracy is getting cheated. The speaker was being asked multiple times for whether this person did right or wrong. Right or wrong. Then speaker asked Kadiyam Srihari, to which party you belong? He told, I belong to BRS only. Then what kadwa is there on your shoulders? By mistake it came, sir, he told. There's so much of misuse. So much of misuse. Then whenever I'm seeing your photos in TVs everywhere, in your background Congress photos are there. It is by AI. His answers, real answers. It is by AI. Speaker, which party? Correct, AI only, correct. Yes, by mistake, yes, correct. By mistake only it came. So, anti-defection law is there, but still it made a fun. 3 years happened, he jumped to the party, but still he didn't got qualified. Like that, every state have multiple examples. Like that, every state had multiple examples. If that is the case, then why we made anti-defection law a constitutional amendment? We added a new schedule called as 10th schedule of the Constitution. We added a new schedule called as 10th schedule of the Constitution. We had 52nd Constitutional Amendment Act also. We had 52nd Constitutional Amendment Act and we made anti-defection law. So for many issues, how the governor was in news, for many issues, how privileges was in the news, for many issues, speaker. Why? Because speaker is having the power to remove if any MP or MLA is defecting the party, is going against anti-defection law, going against 10th schedule of the Constitution. So speaker himself is under threat. So it can be the state legislature, it can be under central also. The Speaker of the Lok Sabha may resign from office, be removed by resolution passed by majority of all the then members of the House. Absolute majority. Removal procedure. 14 days prior announcement. 14 days prior information for the removal of Speaker is required. First point. Who presides during the removal motion of Speaker? Deputy Speaker. The removal of the Speaker is provided in which article? 96. The Speaker will be voting for his removal in the first instance. But when there is a casting vote, 50-50, then he will not have power to vote. In the first instance, when the voting, I am the Speaker. My removal voting is happening. In the first instance, I can vote for myself. If I didn't vote it, then casting vote means 50-50 votes came. Then if I am the final, I didn't vote. Then they will not give me chance. Casting vote will not be given to Speaker when there is a balance. Speaker will be given in his removal procedure only in the initial stages, not in the... Generally, for the bills to be passed, it can be the normal bill, it can be ordinary bill, it can be the constitutional amendment bill. Speaker will be having what vote? Casting vote. Initially, he will not vote for normal bills. He can exercise only under casting vote. But for his removal, only in that condition only, he will not enjoy which vote? Casting vote. This is important. The Speaker can participate in the debate. The Speaker can vote only in the first instance. Speaker cannot exercise a casting vote in this situation. Yes, Speaker is very important. Yes, I will answer your question, Vardhan. He is the person preside over Lok Sabha proceedings. He is the person interpret rules of precedence. He is the person who decide whether it's a money bill or not. He is the person who decide anti-defection. That much important. Decorum of the House, impartial functioning of the House is mainly because of Speaker. Decorum of the House, impartial functioning of the House because of the capacity of the... So he is having 4 powers. Number 1, preside over Lok Sabha proceedings. Number 2, he is the interpreter of the rules of the Lok Sabha. 3rd, he decides money bill or not. 4th, decides anti-defection laws. Then there was a case called as Kihuto Holahan versus Judge Lawn. Kihuto Holahan case we tell. Kihuto Holahan case. See, according to anti-defection law, 52nd Constitutional Amendment Act, 10th schedule of the Constitution, the judgment of the Speaker was final and binding with respect to removal of any MP or MLA. But Kihuto Holahan case very clearly told that every judgment of Speaker with respect to anti-defection law is subjected to judicial review. Under which judgment? Kihuto Holahan case. Okay. Anti-defection is misusing. Who is misusing? Speaker is misusing. He is not taking the judgment. He is also indefinitely spending time. 2 things you remember. Supreme Court fixed timeline with advice of Council of Minister to the Governor. How much time? 1 month. Without the advice of Council of Minister, how much time? 3 months. For the President, how much time? With advice or without advice? 3 months. But that timeline is not set for the Speaker. If anyone is defecting, the timeline is not fixed for the Speaker. For any MP who is defecting. Are you getting my point? National emergency. Why it is in the news? Article what? 352. Article 352. Why it is in the news? 50 years of national emergency. 1975, 2025. National emergency. Article 352, 50 years of national emergency. We can have emergency in three conditions: war, external aggression, and armed rebellion. Armed rebellion. War, understand this, sir. War and external rebellion both same. No, war equals external aggression. Only they came and fighting with us. That is called as external aggression. Third, internal rebellion. In these three conditions, we will have emergency under Article 352. Declared on grounds of internal disturbances. Before 1976, it was internal disturbances. Then it is called as, after 1978, it is called as armed rebellion. Before that, it is called as what? Internal disturbances. Civil press, these all things were been happened. Constitutional changes after emergency. 44th, safeguards. Internal disturbance has been changed as armed rebellion. Written advice of cabinet is very, very important. Allowed fundamental rights protection during emergency. Required periodic parliamentary approval. So there are some changes brought by 44th Constitutional Amendment Act. Number one is written cabinet approval is required. Number one. Number two, for national emergency, there is a requirement of parliamentary approval. Number two. Number three, fundamental rights will not be suspended. Fundamental rights will not be suspended. These are the three things which were been made after 44th Constitutional Amendment Act. Before 44th Constitutional Amendment Act, it was internal disturbance. All the fundamental rights will be suspended. Now what? Fundamental rights will not be suspended. Number two, it is called as armed rebellion. Number three, cabinet written reply. Cabinet written recommendation is necessary to impose national emergency. So, proclamation must be approved by Parliament within 1 month. Special majority in both the houses. Majority of total membership. 2/3 members present and voting. What is a special majority? Special majority means how many people are present in Lok Sabha separately, how many people are present in Rajya Sabha separately. Within that present 2/3 and above should give their approval. Number one. Number two. And that number should be more than 50% of the house. That number should be more than 50% of that house. If these two conditions are satisfied, then only we will call it as special majority. Yes or no? How many MPs are present and voting? In that, more than 2/3 present and voting. Second condition, that approval should be more than 50% of the house. Once approved, emergency will be enforced for 6 months. It can be extended definitely with parliamentary approval for every 6 months. President's rule for how many months it should be approved? 2 months. President's rule after how many months? 2 months. National emergency after how many months? 1 month. Then after both for every 6 months. President's rule after 1 year there is need to get approval from election EC. President's rule simple majority. National emergency special majority. Emergency can be revoked by the president anytime if Lok Sabha passes resolution disapproving it. Special safeguard if 1/10 of the Lok Sabha members request a special sitting must be held to consider revocation, removal. Say affects center-state relations, effects on fundamental rights, effect on parliament. Parliament can extend the term of Lok Sabha by 1 year. Exchange cannot exist 6 months after emergency ends. We have 3 times national emergency up to now. 1962, China War. 1971, Indo-Pakistan War. 1975, internal disturbances. 3 times we have national emergency. Nearly 130 times we have president's rule. From 1950 to 1990, that 40 years we have 90 times, more than 90 times. 62, 71, 75. 62 with China, 71 with Pakistan, 75 with ADM Jabalpur versus Shivakant Shukla. This judgment told that fundamental rights will be suspended, but it was been criticized. No, fundamental rights will not be suspended. Habeas corpus. The Jabalpur judgment is very important. Try to understand this. Listen. Earlier, before 1978, my fundamental right, if someone kidnapped me, if I go to a court under habeas corpus, my body is not found. Habeas corpus. Habeas corpus was also been suspended under Jabalpur judgment. Later it was been removed. It's not an issue. Next, Rahul Gandhi. This person, I told you, beginning, Nirva Modi, Lalit Modi, Narendra Modi, all Modis are thief, he told. Hence, Modi thieves, defamation case. Disqualification of MPs and MLAs. MPs and MLAs, listen carefully. There was a judgment called as Lily Thomas case. Under Lily Thomas case, any person, if he is imprisoned up to 2 years or more than 2 years, they will be immediately suspended. They will be immediately suspended as a MLA or a MP. Before that, what would be there? Under Representation of People's Act 8 Clause 4. Representation of People's Act 1951 8 Clause 4. If any MLA or MP is been arrested for any case with imprisonment of 2 years or above, he will be disqualified. Not suspended, disqualified as an MP or MLA. But he will be reinitiated if he appeal in higher court. In Lily Thomas case, they reversed it and told that if you appeal in higher court or lower court, nothing, no matters. If you once got disqualified under Section 8 Clause 4 of Representation of People's Act, and if you are imprisoned up to 2 years and above, you will be disqualified as, here comes the question, Rahul Gandhi, criminal defamation. Surat High Court, Surat Court gave him imprisonment of 2 years. Criminal defamation by saying Modis are thieves. Under criminal defamation, Surat Court gave him a judgment, Rahul Gandhi, that 2 years of imprisonment. According to Lily Thomas case of 2013, what? If any person who is imprisoned up to 2 years or above will be disqualified as MLA or MP. So immediately Rahul Gandhi will lose his MP seat. Then they went to Supreme Court. Then Supreme Court told it is not applicable to criminal defamation. It is not applicable to defamation cases. It will be not applicable to defamation cases. Hence it stayed. Hence it stayed to the judgment given by the Surat Court. Hence came the issue, MPs and MLAs, how we have to remove. So removal procedures of MPs and MLAs. Remember 3. MPs and MLAs removal procedure is mentioned in 3 sources. Removal of MPs and MLAs are mentioned in 3 sources. First source is Constitution itself. Second is Representation of People's Act 1951. Third is Anti-Defection Law. ఈ 3 సోర్సెస్లో మాత్రమే మెన్షన్ చేయబడింది ఎంపీని ఎమ్మెల్యేని ఎలా తీసేయాలన్నది. సో వాట్ ఆర్ ద 3 సోర్సెస్? Constitution itself, Representation of People's Act 1951, third is Anti-Defection Law. The debate revived after past high-profile cases such as disqualification of Rahul Gandhi following a criminal conviction later stayed by the Supreme Court. Constitutional provision disqualification is governed by 102 and 191. 102 plus 18 is how much? 191. It will repeat. You can add to the center 89 if you add, then there will be the state article. 102 plus 89 is equal to 190. For MPs it is 102, for MLAs it is grounds of legislation. A legislature can be disqualified constitutionally. Holds an office of profit. Means what? If I am an MP, holds an office of profit, you understand this, then all your doubts with respect to office of profit will be solved. Office of profit, it will be confusing. Only one sentence I will tell you. Office of profit means not a private ownership. For example, you became MP. You are a owner of a supermarket. Then it is not called as office of profit. You became MP, but silently you are working as an advisor to some government university and you are taking government money. It is called as office of profit. You won as an MP. You are working as an independent director of BSNL without telling to anyone, silently. As an independent director of BSNL, you are drawing money from government. It is called as office of profit. You became an MLA. Without making noise, you are working like an officer somewhere. It is called as office of profit. Office of profit means taking money from the government through the government agencies. Then only it is called as office, not private. Pension you can take. Pension is not called as office of profit. All retired, they will join politics now. Whoever retired, they join politics. Again, they will become busy. Pension will not be called as office of profit. So, holds an office of profit, then he will be disqualified. Unsound mind, disqualified. Undischarged insolvent, when he is not paying the loans, it is called as undischarged insolvent, not a citizen of India, disqualified under law made by Parliament. These are the things which are being mentioned by Constitution. Disqualification under law, which law? Criminal conviction, corrupt electoral practices, failure to file election expenditure accounts. Corrupt electoral practices, which person? Indira Gandhi. Because of which she imposed what? National emergency. First is Constitution, second is Representation of People's Act, law. Three things what? Criminal conviction, like rape. Second what? Corrupt electoral practices. Third, failure to file election expenditure. ఈ మూడు గుర్తుంచుకోవాల్సిందే. ఓవర్సీస్ చేయొద్దు. మూడు, ఈ ఐదు. Holds an office of profit. Unsound mind. Undischarged dissolvent. Next, citizen of India. Any law made by the Parliament. Which law made by the Parliament? RPA. What are three things? Criminal conviction. Second, corrupt electoral practices. Third, not filing the election expenditure. Disqualification due to defection, which is called as anti-defection law. So there are three sources for the removal of an MP and MLA: Constitution, Representation of People's Act, anti-defection law. In your mains also simple. So any question with respect to removal of any representative, three things: constitutional provisions, 5 provisions; representatives of People's Act, 3 provisions; anti-defection law; voluntarily giving up party membership; voting against party member; independent member joining political party; nominated member joining any party after 6 months. So these are the 4 things. Who is the decision authority? Speaker. for Lok Sabha and Legislative Assembly. Who is the speaker, deciding authority for Rajya Sabha and Legislative Council? Chairman. That's it. 5 provisions for Constitution, 3 provisions for RPA, 4 provisions for anti-defection. What are the 4 provisions of anti-defection? First one, voluntarily resigning. Number 2, against whip. Third, independent member joining political party. Fourth, nominated member joining any political party after yes. Authority to decide disqualification, decision taken by President based on Election Commission's opinion, decision taken by Governor based on Election Commission opinion. See, yes, independent member cannot join the political party. No, independent member cannot join as per the law. If independent member, if he joins, which party will join? Ruling party will join. Ruling party only will join. Then why ruling party will disqualify him? Loophole of anti-defection law. Technically, he should be disqualified. I got your doubt. Then independent member, why he is not disqualified? Because it is getting misused by whom? Speaker. Nominated member will not be disqualified till 6 months. After 6 months, he will be disqualified. Why these 6 months, tell me? Yes or no? Nominated member, independent member, if he join a political party, he will be disqualified technically. They are not getting disqualified. Why? Because anti-defection law is getting violated. Fourth point, what we discussed, nominated member will be disqualified if he join any political party after 6 months. And 6 months kanda mundu join avvacha? Appudu disqualification vartinchada? Enduku? After 6 months also he can become minister. Are you getting my point? Manoj can tell me answer. Nominated member joining party after 6 months will be disqualified. Why not before 6 months? ఆ జాయినింగ్ 6 months తర్వాతనే డిస్క్వాలిఫై అవుతారంటున్నారు. మరి ముందు 6 monthsలో జాయిన్ అవుతే ఎందుకు డిస్క్వాలిఫై చేయరు మరి? Those everyone read Lakshmikant, tell me answer now. Why only after 6 months? అంతే కదా, 6 months ఏం పాపం చేసింది? Tell me, Vardhan, whether the question is valid or not. Nominated member, that means within 6 months he can join any party. Constitution is giving scope. Anti-defection law is giving scope. If you want to join, jaldi you go and join. Before 6 months. After 6 months we will not allow. Why? See, it is told that nominated member joining party after 6 months will be disqualified. But he can join before 6 months. Then why they gave, means voluntarily we are telling you join man within 6 months. జంప్ చేస్తావా చెప్పు, జంప్ చేయి. 6 నెలల్లోపు జంప్ చేయి, తర్వాత మాత్రం నేను ఒప్పుకోను. మరి 6 నెలల్లోపు ఎందుకు? సో వాళ్ళకి ఏ పొలిటికల్ పార్టీ యొక్క నాలెడ్జ్ లేకపోవడము, ఏ పొలిటికల్ పార్టీతో అఫిలియేషన్ లేకపోవడము, న్యూట్రల్గా ఉంటారు. 6 months తర్వాత మరి ఎందుకు? అలానే కంటిన్యూ అయితే బెటర్ కదా, న్యూట్రల్గా ఉంటేనే బెటర్ కదా. నామినేటెడ్ మెంబర్ కదా అని, నామినేటెడ్ మెంబర్ లానే ఉండాలి కదా. Homework, tomorrow I will tell. Yes. Inter-parliamentary union. Recently what happened? A inter-parliamentary union was being conducted at Geneva, Switzerland. So every year there will be inter-parliamentary union will be conducted. This year 2025 the inter-parliamentary 2025 inter-parliamentary union was being conducted in Tashkent, Uzbekistan, under Om Birla. Our parliamentarians went to Tashkent, Uzbekistan, And all the countries, nearly 180 countries who are having parliamentarians, democratic parliamentarians, attended that union, which is called as IPU, Inter-Parliamentarian Union. There we will discuss about democracy, more democracy, what we should do. This all discussion will happen in this Inter-Parliamentarian Union. This session was been conducted where? Tashkent, Uzbekistan. Polity point of view, there was a union which has been happened. Who is the head of it? Om Birla. 150th Assembly. Which assembly this is? 150th Assembly of Inter-Parliamentary Union happened at where? Tashkent, Uzbekistan. It started from where? 1889 onwards. It's a global organization of national parliaments. Promote parliamentary dialogue and diplomacy, strengthen democracy and representative institutions. For that purpose, we will be conducting it. So, Government of India went, not Government of India, Central Legislature went. Central Legislature headed by Om Birla, the Speaker of the Lok Sabha, took this particular group to Tashkent. Which summit it was? Number 150th summit. Hence, it is in the news. Inter-Parliamentary Union. What we will discuss global political issues, recommendations for international parliamentary action. There will be 3 bodies comprising 3 policy body, executive committee, standing committee, executive 17-member body that oversee IPU's operations. The main thing is 150th time Inter-Parliamentary Union was being conducted in Geneva, in Switzerland, in Tashkent, in Uzbekistan, mainly to discuss about the democracy, mainly discuss about representative institutions, mainly how to function our parliaments more effectively. It was started in which year? 1889. To make democracy more stronger. Why it is in the news? Because which year it is? 150th year. Consists of national parliaments of sovereign states. How many people are there? 180 plus member parliaments and several associations. Biannual IPU assemblies will be conducted. Global parliamentary report. Women in parliament. 3 reports will be released by this. What are the reports released by inter-parliamentary unions? What are the reports released by inter-parliamentary union? First report is what? Global Parliamentary Report. Second report is what? Women in Parliament report. Third is what? Provide technical assistance to parliaments. 3 reports will be published. First report is Global Parliament Report. Second is Women Parliament. Third is Technical Assistance. Like a manual. Which of the following books are being released by Inter-Parliamentarian Union? First one is what? Global Parliament Report. Second is what? Women Parliament Report. Third is what? Technical Assistance. Election related issues and Election Commission of India. If you remember what happened. Didi. Which Didi? Mamata Banerjee. Mamata Didi asked that Election Commission of India is working for BJP. Election Commission of India is working for BJP. It asked very strongly for the removal of Election Commission of India. Hence, it is in the news. Then what happened? Few judgments came. Government of India made some legislations and Chief Election Commissioner is appointed by a body constituting what? Prime Minister, Leader of Opposition and Union Minister appointed by the Prime Minister. These 3 people will be forming a committee to appoint a Chief Election Commissioner. Before that, Supreme Court gave one judgment. In that judgment, it told 3-member body. That is, one is Prime Minister, Leader of Opposition, Chief Justice of India. But government made a law and removed Chief Justice in place of Chief Justice, whom they brought Union Minister appointed by PM. So, Election Commissioner removal was being demanded by Trinamool Congress very strongly. Hence, it was in the news. Election Commission. Elections in recent years have raised debates on issues such as Model Code of Conduct Enforcement, use of money power electoral bonds, EVM, VVPT, appointment and independence of election commissioners. Article 324 West, independence and functioning of Election Commission of India. Election Commission of India will be having the power to conduct elections for President, Vice President, Lok Sabha, Rajya Sabha and State Legislature. Then State Election Commission will be having the power to conduct elections for whom? For local bodies, Gram Panchayats and municipal bodies and legislative councils. Three bodies elections will be conducted by State Election Commission. One is Gram Panchayat elections, municipal bodies, and legislative councils elections also will be done by State Election Commission. Central Election Commission's election will be done by for whom? Lok Sabha, Rajya Sabha, President, Vice President, and State Assemblies. State Assemblies. Whereas State Legislative Council will be done by whom? State Election Commission. Composition. We have Election Commissioner, Chief Election Commissioner, and 2 election commissioners. Totally how many? Election Commissioner, and Chief Election Commissioner. 3-member body will be there. Appointment made by President of India. Functions of Election Commission is conduct elections, Parliament, State Legislature, President and Vice President. Preparation of electoral rolls. Recognition of political parties. Register of political parties. Giving status of national symbol and national status and state status, regional status, and symbols for the political parties will be given by whom? Election Commission of India. Allotment of election symbols. Model code of conduct will be enforced by whom? Election Commission of India. Now you tell me, model code of conduct, whether it is present in the constitution? No. Model code of conduct, whether it is made by any law? No. Whether a legal backing is there for model code of conduct? No. It is just a regulation given by the Election Commission of India. It doesn't have any legal backing. It is not there in the constitution. It is not there in the legislation. It is nowhere there. It is just a regulation given by Election Commission of India. It is just a GO released by a department, not by the government also, released by the department called as Election Commission of India, by the name called as MCC, Model Code of Election Schedule. Powers of Election Commission: cancel, postpone elections in case of malpractice, order repoll, issues guidelines for campaigning expenditure, supervise EVM and VVPAT. Independence, CEC removal process similar to Supreme Court judge. Very important. Constitution mentioned Chief Election Commissioner will be removed on the same procedures of Supreme Court judge. No procedure, same procedure as Supreme Court judge. What is Supreme Court judge? Impeachment. Removal procedure is what? Supreme Court judge. So remember like this. Don't go that. This much only. Chief Election Commissioner of India will be removed on the same procedures of removal of Supreme Court judge. Election commissioners uన్నారు కదా, other 2 election commissioners will be removed on the recommendations of CEC in order to maintain the authority of the CEC. But CEC is removed on the same procedure of C. Every election commissioner will not be removed on the procedure of removal of Supreme Court judge. Only CEC will be removed on the procedure of Supreme Court. Other ECs on the recommendations of CEC. So that the CEC will be exercising the authority on the CEC body. Anup Baranwal versus Union of India. Which judgment? Anup Baranwal versus Union of India. The Supreme Court told 3-member. Who? Prime Minister, Leader of Opposition and CGI. To appoint whom? CEC. But Parliament made a law called as what? Election Commissioners Act 2023. How many people? Same Prime Minister, same Leader of Opposition, but in place of CGI who? Union Cabinet appointed by PA. He will be holding the office till 6 years until he gets the age of 65 years. 6 years or 65 years. Removal. Removal procedure is similar to that of Supreme Court judge. There are 2 things were being mentioned. One is proved misbehavior and incapacity. Incapacity means mental. Proved incapacity and proved misconduct and incapacity. Generally for everyone one will be there. What is that? Insolvency. But for him insolvency is not there. Means he can take loan and he cannot pay, no problem. Only 2 procedures are there. Proved misbehavior and Incapacity. Parliament passes a resolution in both the houses, requires special majority, majority of total membership, 2/3 of members present and voting, President removes the CEC. Same procedure like Supreme Court judge. Other election commissioners cannot be removed directly by Parliament by the President on the recommendation of CEC. Anti-defection law. Constitutional based anti-defection law is contained in 10th schedule, 52nd Constitutional Amendment Act to prevent political defections. Grounds for disqualification is voluntarily giving up a party membership, going against the whip, an independent member joining a political party, a nominated member joining a political party after 6 months. Why the law was introduced? Frequent party switching by legislature led to political instability, popularly known as Ayaram and Gayaram. Maintain party discipline, prevent unethical defections, ensure stable governance. Decision taken who is who? Speaker, chairman, and the decisions are subjected to judicial review. See, 52nd Constitutional Amendment Act told 1/3 of the members, if they jump into another party, then they will be not disqualified. But 91st Constitutional Amendment Act of 2003 told not 1/3 but 2/3. If 2/3 of the members jump into another political party, then it is called as merger. They will be not disqualified. Earlier, how many are allowed? 1/3. Now, how many are allowed? 2/3. So, if 2/3 and above are jumping, then they will be not disqualified. Earlier, 1/3 and above are jumping, then they will be not disqualified. 42nd told only 1/3, it is merger, but now 91, it told how much? 2/3. Kihutu Holhan, speaker decision is final. Yes. See, Kesham Meghachandra Singh. Kesham Meghachandra Singh versus Speaker, Manipur Assembly. Reasonable time it told. Again, 3 months is not fixed. Reasonable period it told. There is no timeline. See, tell me the answer. A deputy chairman of Rajya Sabha is not disqualified under anti-defection law when he or she voluntarily gives up the membership of his party. Deputy chairman who, man? Second, a defection by at least 1/3 of the elected members of political parties is considered as a merger. A defection 1/3 or 2/3? Abstaining from voting by a member of a house against the directives of his party can be called defection. Yes. First one, deputy chairman of Rajya Sabha is not disqualified under anti-defection law when he voluntarily gives up the membership of his party. He voluntarily gives up the party of his? Yes. See, PYQ 2024 question this. Simultaneous elections. 129 Constitutional Amendment Bill. Simultaneous elections, Jameli elections, central parliament and state legislatures, everywhere the elections will happen at one point of time. 138 Constitutional Amendment Act is also there. One amendment bill, CAB. 130th Constitutional Amendment Bill will tell that after conducting of elections for state legislature and central legislature, within 100 days, local body elections also should happen at a time. So, 2 simultaneous elections are happening. First simultaneous elections is central parliament and state legislature. Within 100 days of the completion of the central parliament and state legislature elections, within 100 days, local body elections also should happen. So that once the elections are completed, then we should not think about elections for another 4.5 years. Then we will focus only on administration. That is the main motto of simultaneous elections. One body was being constituted under chairmanship of Ramnath Kovind. Lok Sabha elections, reduce frequent elections, minimize administrative budget, ensure policy continuity and governance efficiency. Synchronization of elections, introduction of new constitutional mechanism, transitional arrangement. What is transitional arrangement? If less than 6 months time is there, for example now, Telangana is there. 2028 November, 5 months, 6 months, 5 years will be completed. General elections will happen in 2029 April, May. But state legislature elections of Telangana will happen in 2028 November. Why? Because elections happen in 2023 November. But simultaneous elections means happen in the month of 2029 April, May. But state legislature of Telangana is going to complete 5 years by 2028 November. If less than 6 months is there, we can extend. That is called as transition. If more than 6 months is there, elections for that time, elections for that period. That is called as simultaneous election. Only for that period elections will be conducted. Article 83, see, Article 83 provides that Lok Sabha has a normal tenure of 5 years. Fixes the normal 5-year terms for state legislature. How much article? Which article? 83. 83 plus 79 how much? 83 plus 89 how much? 83 plus 89 how much? 172. 85. Empowers president to summon, prorogue and dissolve. 174. Gives the governor power to summon. 87 plus 89 how much? 174. 85 plus 89 how much? 174. So center and state. This 5. Which articles need to be amended for 129 Constitutional Amendment Act? 83 plus 89. How much? 172. 85 plus 89. 174. Then 356. These are the 5 articles which need to be amended. What are the following articles need to be amended for simultaneous elections? 83, 84, 172, 174, 356. 130 Constitutional Amendment Act. Within 100 days, after the conclusion of simultaneous elections, there will be simultaneous elections for local body elections, Gram Panchayat and municipal bodies across India at a time. Within 100 days. Comes under which Constitutional Amendment Bill? 130. Synchronization election, local body with the national election. Panchayat election should be conducted within 100 days. 243E, 243K, 243U, 243ZA. 4 articles will be amended. Which are the articles amended? E, K, U, K. 243. Reduce frequent election cycles, ensure administrative efficiency, improve policy continuity. Judicial review, scheduling. But what is happening? Judicial review and scheduling. For example, I will tell you. In Telangana, local body elections happened in 2025 December. Gram Panchayat. The tenure completed 2023 January 1st. So 2023, 2024, nearly 2 years completed. More than 2 years completed. They didn't conduct Gram Panchayat elections. So frequent Gram Panchayat elections are not happening, hence a issue. So the elections are happening, the judiciary is entering and judiciary is giving the judicial review. The judiciary is telling that please conduct the elections within 6 months, then the elections are happening. They are showing so much of excuses. So conducting of elections for local body elections also is under the control of judicial review. So if we make Constitutional Amendment Bill 130 and if you allow to have a simultaneous elections for local bodies also, the state government is not making the elections, so it should be under the control of Election Commission of India. That is the demand. If it is under the control of Election Commission of India, the local body elections also will be conducted as per the time. If not, many states, it can be Telangana, Andhra Pradesh till now not happened. Andhra Pradesh didn't happen, Kerala didn't happen, Andhra Pradesh didn't happen. So what is happening? The grassroots level democracy is getting delayed indefinitely. For example, for Andhra Pradesh, nearly 3 years completed. They didn't conduct any local body elections. Kerala didn't conduct and Tamil Nadu didn't conduct. So they are showing what, for example, frequent Uttarakhand, We are not, disasters are happening, how we have to conduct elections. See, don't link disasters with elections. If that is the case, then ML elections also should be postponed. Then Lok Sabha elections also should be postponed. Then these disasters are not against ML elections and MP elections. Why only for local body elections? So, the local board elections need to be conducted on timely. Yes. Tomorrow we will discuss about federalism. What all topics we discussed today? Which are all are in 2025. What are topics which we discussed? Parliament privileges, expected privileges. Second, Schedule 5, Schedule 6. Next, Governor's timeline. Next, rule, national emergency. Next, disqualification of MPs and MLAs. Ladakh. Next, impartiality of the speaker. Next, inter-parliamentary union. Next, elections, conduction of elections. See, it seems to be 10 topics only, but overall topics we discussed, which are in the news. Okay, tomorrow we will discuss remaining topics. Thank you.